What do I do about my job loss or reduction in income? Are there any proactive measures that I can take regarding child support? What consequences will there be if I delay? What can I do in the meantime? These are the few of the questions and more that we will delve into today. I'm Michael Miller, a partner at Cole Miller PLLC, located in Vienna, Virginia. We're a family law firm serving primarily in the Northern Virginia area. I analyze challenges and find affordable solutions for families as they address their legal needs. Now, in our previous videos, we reviewed the executive orders from the governor and the judicial emergency orders from the Virginia Supreme Court that came out between mid-March and the beginning of June 2020. As with our previous discussion on matters of custody and visitation in the time of COVID, we considered the courts being shut down or at least reducing the available time they had for hearings. And we also looked at the thousands of cases that are accumulating in light of the reduced hearing time available. Now, these new orders from the Supreme Court have come out with recent provisions that have put into place remote hearings. However, the time allowed will easily be taken up as 10-minute matters turn into 30-minute matters because people are going to need to activate or mute their cameras, their speakers, their telephones, whatever the case may be. They're going to have to explain to the court and the opposing party or opposing counsel what documents they're referring to. And there's also going to be the issue of, how do you get witnesses oriented to testify properly? Now, our previous discussion on custody, we looked at the likelihood that either side could be seeking enforcement or seeking modification. However, in the support scenario, it is much more likely that only one side will be seeking to enforce the support. The payee will be doing that, and the payor will be the one seeking modification. Now, family support is based on income. A Bloomberg report that came out on June 4th says that 1.877 million more Americans filed for unemployment benefits for the first time. This was a higher number than expected. It was 1.83 million. For the 11-week period, there's now a total of 42.644 million Americans unemployed, dramatically more than any time in American history. Now, the law provides that when a material change of income occurs, that the support based upon that now changed income may be modified. Now, by material change, what we mean are facts today that did not previously exist at the time of the last determination or hearing, but would have materially changed the outcome of that determination had those facts been known. A couple dollars here or there, probably not going to be material. A couple $100 could be material compared to the related obligation that's being changed. Now, in particular, for support modification, there's a court case that addresses this matter. And the case where we're looking at now is from the Virginia Court of Appeals. It's Yohay versus Ryan, Yohay, Y-O-H-A-Y versus Ryan. It can be found at 359 Southeast 2nd, 320, or 4 Virginia Appeals 559. This is a 1987 case. And the relevant part that it says is the Court of Appeals here saying that we agree with the trial court's statement that the existence of a material change in circumstances does not automatically mandate a change in the amount of support. Court of Appeals disagrees, however, with the trial court's further ruling that the moving party must prove that a change in the amount of support would be in the child's best interest. The court then continues later on in the next column that the moving party in a petition for modification of support is required, therefore, to prove both the material change in the circumstances and that such change justifies an alteration in the amount of support. So the thing to look at here is that best interest is a custody standard. It's not relevant to a support determination. I mean, practically speaking, how would one demonstrate that less support is to the benefit of a child? So now, but we still have the burden is on the moving party or the moving parent to show that the job loss or income reduction is not due to any kind of bad faith, misconduct, or other voluntary underemployment or unemployment. There will be a heightened burden especially in a child support modification case, for the payor to really shine the light into all the corners of their finances. They're going to have to come in with account balances, expenses, income statements, tax returns, and everything else to show that there's a legitimate loss of income here. Now, that being said, with the job reports as they are, I would expect that the court will have a sympathetic disposition, unlike in times of economic expansion when there are ample employment opportunities available. Now, the critical point here is, when do you file your petition to modify? And the answer is as soon as possible. The reason for this is to preserve the earliest retroactive effective date. So what does that mean? So what will happen is you will initiate, either yourself or by counsel, a petition to modify support. In the ordinary course of business, you would go into the JDR court, file your petition. A few months later after filing, there would be a status conference, possibly ordered to a mandatory mediation. Then a few months after that, there would be a hearing to modify support. So this could take anywhere from a few months to close to a year. Similar process in the circuit court, probably no status conference, possibly a mediation, and then you have the hearing come up there at the end. So first, you want to file early in order to get the earliest trial date. As we said earlier, the courts have limited time. There's a huge backlog of cases, so you want to get in the line as soon as possible to get the earliest trial date, because we'll talk about the consequences that the delay could have on you. Second, you want support, if it is reduced, to be the new amount to be effective retroactively. So keep in mind, you're still obligated to pay the ordered amount of child support during the pendency of the hearing. However, the court can make the new amount retroactive. So let's take a look at Virginia Code 20-112. And that code section says in part that no support order may be retroactively modified, but it may be modified with respect to any period during which there is a pending petition for modification in any court, but only from the date that notice of such petition has been given to the responding party. So, this is where the limitation is on the retroactive effect. You may come in and be as sympathetic as person as can be, but no matter what the judge wants to do, the judge can't go back any earlier than the date of the filing. Now, keep in mind, for a modification, the retroactive effect is discretionary as compared to an initial determination under Virginia Code 20-108.1. And Virginia Code 20-108.1 in paragraph B, it provides that liability of support will be determined retroactively, so it's a shall be determined mandatory, for the period measured from the date that the proceeding was commenced by filing the action, provided the complainant exercised due diligence and service. So again, there's the notice or the requirement here that you provide notice and get the other side served as soon as possible. So the recommendation here is don't file the petition and then sit on it for months and months. So here are how the scenarios can play out. Scenario number 1, parent loses her job, no income. They exhaust her savings to continue paying support. The savings runs out. Then several months of missed support payments. All of those missed months constitute an arrearage that will carry a 6% rate of interest. Finally, there's a court hearing, and the judge orders that all those payments in arrears must be fully paid, plus 6% interest on top of that, plus the future support going forward of the new amount, because you can have a new amount, but it won't be retroactively effective. You'll be paying that. So you're paying the arrears, the interest, and the new amount. Now compare that to scenario 2, where parent loses her job and they file an immediate petition for support. Now, the obligation of support may continue, but at the eventual hearing, the judge could go so far as to zero out the support obligation and then make that retroactively effective back to the date you filing. So now you have the benefit of no arrearage, no interest on the arrearage. Now, this is an extreme example, but it does highlight the difference of filing as soon as possible. At the eventual hearing, if the court finds a material change, then we do the typical guideline determination under Virginia Code 20-108.2 with the further consideration whether the guideline amount is unjust or inappropriate, which then triggers a deviation from the guideline amount as provided in Virginia Code 20-108.1. Now, with regard to modification, there are two separate but related issues. The first of these related issues is spousal support. Now, it's not uncommon to see spousal support to be fixed and non-modifiable in settlement agreements. So if that's the case, the payor's job loss becomes irrelevant. Now, with regard to child matters of custody and support, public policy says that parents cannot contract away the court's power to look after the welfare of children. So typically, support would be left modifiable in instances where spousal support would be not modifiable in agreement. The one kind of exception or unusual circumstance that happens with that is that you could have it that child support be set for a year or two before a party could petition for modification. So in essence, you're imposing a moratorium on the modification. Now, the second related issue here is payee job loss. So we go back and say that the total amount of child support is based upon both parents' incomes. Then we take that amount of support and we share between the parents in proportion to their incomes. Now, it is frequently not in a payee's interest to seek a modification of support in the event of their job loss or unemployment. For example, child lives with parent A, parent B pays support. Parent A becomes unemployed, so parent B would be 100% responsible for the child support based upon parent's B income if you sought a modification. Odds are it's going to come out to be about the same money, so why would you go through the burden and expense to file the petition to modify, go to court, and end up changing nothing? Now, keep in mind that just because the payor has lost or reduced income, that does not mean that the child goes into suspended animation. Okay, the child's still going to need food, clothes, utilities, transportation, activities, and everything else that has to be provided. But with one parent unemployed, that's solely going to fall on the other parent. So recommended practice would be for the unemployed parent to seek reemployment as soon as possible and to seek to restore child support at the first opportunity. Also keep in mind in this scenario that child support and parenting time are entirely unrelated. One is not conditioned on the other. One does not pay child support in order to have access to their children. Visitation would proceed as ordered regardless of the support situation. Now, in later videos, we will revisit the determination and modification of child support in more detail. What we wanted to cover today, the critical takeaway is file the petition to modify sooner rather than later. And with the new provisions that are available for electronic and remote filing, this becomes easier than ever. So that's our lesson for today, and we'll pick up tomorrow with matters of equitable distribution and support in a divorce case.